Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. It is the first week of June 2025, and this week we've got one that has slipped under the radar, but we think is one of the hottest legal topics that needs to be highlighted. We're going to be talking about the Supreme Court decision of Apache Stronghold versus United States. This is one of the Native American decisions based on religious freedom, both in the Constitution and the Religious Freedom Act. We're then going to combine that with other religious freedoms and some of the case law that has come up through the last couple of decades, and specifically with regard to non-Christian religion. So that's our topic of today. I'm Vile Tehrani. I'm an attorney with Tehrani Law, LLC, because you never need a lawyer till you do. I've got 20 years of experience prosecuting, defending, doing civil law, mostly doing trial work. And I am pleased to be joined with our Constitution scholar, Dr. John Vile from Middle Tennessee State University. He's the Dean of the Honors College there, and it's great to have you helping us with these constitutional issues.
Thank you. Good to be here.
Yeah, I know you have the Encyclopedia of the First Amendment. Everybody go to the website of Middle Tennessee State University. It is a free resource. This is the Encyclopedia of the First Amendment, and I know you have been so instrumental in creating it from the beginning and keeping it alive and active. And this is one of the cases you've just written an article on for the First Amendment Encyclopedia.
Yeah, and I think as we recorded, I'm not sure it's yet been published, but surely it won't take long. And to be clear, one of the reasons I want to give it some attention is it's a decision not to decide.
Right.
It's a denial of certiorari, which means that 4 members of the court or more decided that they would leave the existing opinion in place, which in my judgment is a completely erroneous opinion.
Mm-hmm.
But what's fascinating about it is Judge Gorsuch, who is known for having fair amount of sensitivity to Native Americans as well as to religious issues, he writes a striking dissent from the denial of certiorari, joined, by the way, by Justice Clarence Thomas, who I'm not sure I would have predicted would have joined that, but Gorsuch writes what I think is a very compelling decision, saying that the court should have taken this up and that the lower court has been erroneous.
Right. And I definitely want to highlight that is I like the way you phrased it. It is a decision not to decide. So a denial of certiorari is the Supreme Court saying we're okay with the Ninth Circuit Court of Appeals opinion. We're going to leave that essentially as the case law. So that's going to be the decision. It's basically an agreement. That's the law that stands. That's the interpretation that stands, and we're not going to change it. Where you're saying Justice Gorsuch says, well, okay, you say no, I say we should have, and I believe that we should have made a different decision than the Ninth Circuit Court of Appeals made.
And by the way, because we probably need to fill in, we discussed a case 2 or 3 weeks ago in Oklahoma that dealt with whether governments could give direct financial support to religious charter schools. And you remember it's a very tough issue here between
Yes.
Are you promoting free exercise rights or are you establishing religion? Because previous cases had dealt primarily with pass-throughs through parents rather than direct support of a religious institution. And I think we mentioned during that discussion that Justice Amy Coney Barrett may or may not decide to participate. She has been a strong advocate of charter schools, and it turns out she decided that she should recuse herself, not participate, and the result was a 4-4 decision that effectively left in place the circuit court decision, which had said that there would be no aid in a case like this. So it was a very consequential decision, and I really tip my hat here to Barrett, because we're in a time where particularly 2 justices in particular Alito and Thomas
Right.
have shown, in my judgment, questionable judgments in regards to, you know, political activities in the one case in their home and to another gifts and whatever that they have accepted.
Right. Possible bias and influence,
Right.
improper influence.
Right. And here's someone who almost surely, I mean, she had been a professor at Notre Dame, you know, very, I just visited France, so I have to
You've got
say
the
Notre
other.
Dame, as they say it in France rather than Notre Dame as we
Notre
would say it
Dame.
here. Um, but you know, this is probably an issue. And Mike, you know, I would guess there's a 90% chance if she had had to vote for it that she would have voted to support the aid, and she decided to recuse herself instead. And I think that's you know, not so much because of the outcome, but just she seems to be heeding what was standard when I began teaching, which is particularly judges must avoid the very appearance of bias.
Of impropriety.
Absolutely. So I
Exactly.
commend her on that, even if it was maybe something that was, you know, she would have preferred to have been able to decide.
Yeah. And the younger generation, mad props to her. Definitely agree. And Dr. Vile's like, I still don't know what that means.
I don't.
It's okay.
Okay.
For
Did it
those who are
happen
younger,
before or after the U.S. Constitutional Convention?
a tad bit after, just a
Okay,
little.
well, that's probably why I'm not familiar with it.
So while we continue, before we do that, it is the weekly wine. I have been very lax in getting some more wine and in drinking wine here. I'm afraid we've been taping at odd times and have more needed the caffeine than anything. So today I've actually got some more caffeine, and so does Dr. Vile. There, you're holding up the campus's what, Pepsi?
Yes. Yes.
Yeah, it breaks my heart that MTSU does Pepsi rather than Coke, but Dr. Vile supports the campus and therefore Pepsi. So there it is. I've got a Cherry Coke Zero is what I'm drinking today. I love the cherry flavor, but I've got it in one of our coffee tumblers. So I've got our beautiful purple coffee tumbler saying, allegedly, this is coffee. So pick one up on your own. We've got it in purple, and which is our color, and we've got it in black as well for those of you who don't want to do the lovely purple. Go to www.thelawunscripted.com to find that tumbler and to find other fun merchandise. We've got a lot of shirts out there, especially for law students who love plays on words and different fun legal sayings and funny phrases. And we've also, for those of you who are coming up on the bar this summer, we've got a lot of bar classes. So we teach the main 8 classes regarding the bar, such as torts, constitutional law, criminal procedure, civil procedure, etc. So check those out and get some, and follow us on all of social media. And you too can have fun with us as we go along. And this is supporting the Law Unscripted supports and promotes the Legal Weekly Wine. So now that we've got that, let's go to Apache Stronghold. So it's technically Apache Stronghold versus United States. It was decided on May 27th of this year, just a couple of days ago, essentially. And Dr. Vile, I know we've discussed that it's basically a holding to keep the lower court's decision.
Right. The court decided on the 27th that they didn't have 4 people who thought that it should be given review. And that leaves the lower court decision in place, which allows the transfer or sale, I'm not sure which it is. Basically, you have an area called Oak Flat, which is in Arizona. It is a site that for 1,500 documented years, the Apaches have considered a sacred site. They have a coming of age ceremony there for young women, which seems sort of gross to me. They dunk them in white clay, and then godmother or somebody comes and sort of wipes some of the clay around. But it's intended to make a connection. They believe that this is near the birthplace of the earth, and this is the connection that is made with their ancestors. So they have been consecutively using, I mean, almost as long, well, Christian church goes back 2,000 years, and this is,
Sure.
I think it's 1500. But for a long time. And it turns out, as often has happened in American history, that, this is land that was originally owned by the Apaches.
Right.
It was conquered by Mexico. It was transferred to us by treaty. And we actually had three treaties that were agreements dating back to 1905, which recognized the sacred nature of this territory. And then they discovered copper. And so the agreement would give right in the middle, there's a zone, yay big, and
Right.
about 90% of it, they are giving permission to this copper mining company to dig a trench 1,500 feet deep and close to 2 miles wide.
In the middle of the Apache land.
Right. I mean, it would be, to go back to the example that I just used, it would be like the government of France saying, we've discovered gold under Notre Dame. We're going to blow it up in order to mine gold or uranium or whatever.
Sure.
In the National Cathedral, if you could imagine, imagine, and of course, people read this decision, and I mean, I look at the beliefs here, and I say, well, that seems sort of silly.
Right.
It's the dwelling place of the saints, the Holy Spirits. They rise up and whatever. That's not my belief as a Christian. But many of my beliefs as a Christian differ from beliefs of other Christians.
Exactly. And that's
We,
the whole point of America. A lot of the founding of America was for religious freedom, for
That's right.
differences in religion, so people could escape the Roman Catholic Church and the Church of England and establish their own. We had Pilgrims and Quakers, and we've had Jehovah's Witnesses, the
Well,
Mormons.
and again, where the court has sometimes fallen short, actually, one of the major cases where they fell short was, it was Employment Division versus Smith
Right.
some years ago. Prior to this time, the court has never said that religious freedom is absolute. Don't, you can't have child sacrifices,
Right.
and there are other, actions that a religious group could take. If you're advocating terrorism, that's not considered to be appropriate. But prior to Smith, Employment Division versus Smith, the court has said anytime the the government was going to make a decision that had a substantial effect on religion, it had to show a compelling state interest and a substantial relationship between what they were doing and what that interest was. And in Smith, the court decided that it's a sort of unusual decision, but you had drug counselors who were Native Americans got fired from their job because they were ingesting peyote. Now, they weren't
Right.
doing it recreationally, they were doing it as part of Native American services, and
Right.
they were denied unemployment benefits. And the court shrugged its shoulders and said, well, too bad. You have a law that's on its face neutral. If they lose out, so they lose out.
Right.
And then Congress came back with the Religious Freedom Restoration Act, which said, no, we want to restore the earlier
Court
standards that
decisions.
you were using. We think there should be a compelling state interest before you interfere with these things. But this court, for some reason, goes back to a decision that preceded Smith, which is in itself a little bizarre. It's a case known as Ling, and
All right.
I don't remember the full name
Versus,
of it.
there we go. I've got it. Ling versus Northwest Indian Cemetery Protective Association. And that's
Yeah,
1988. So that does
yeah,
predate it.
yeah, and that's a decision, frankly, that I didn't agree with either. Um, which was, yeah, Native Americans call this place in a national park. They call it sacred, but we like to do logging and we like to have a place for tourists to come. We're going to build a road right through the middle of it or near it. And the Native Americans said, well, this destroys the sacredness, the tranquility of the place. And the court basically said, too bad.
Well,
But
it said, didn't it make an exception that it doesn't apply to We can't prevent access to religious exercise, but that doesn't apply to government real property, which is land.
Well, I think actually that distinction, and I would have to go back and look, but I believe that distinction actually comes out of the decision that was being appealed in this Apache Stronghold case.
Okay.
Apache Stronghold came up with this you can't do religion that completely prohibits somebody's free exercise, or there's another qualification. But if it's government property, then there's going to be an exception. But even if so I think that's newly formed. But the problem with Ling is Ling did not completely destroy a property. It just
Right.
made it, I mean, it's noisier. It's harder to worship if there are jackhammers outside as
Right,
opposed
and
to
it
if
made
there
a
aren't.
road across it versus destroying a
Right.
lot. I mean, not that a road doesn't destroy specific parts of
Right.
it, but it didn't completely.
Yeah, I thought Ling, without knowing that much about it, I thought it was terribly insensitive to Native American religion. And the key here is, and this is where, I think we had not threatened, we had promised months ago that we were going to talk about Jehovah's Witnesses.
Yeah,
And this is probably an appropriate time to do so.
absolutely.
You know, Jehovah's Witnesses resemble Native Americans in that there aren't that many compared to Christendom as a whole. And by the way, I think they would consider themselves Christians. So we're talking about minority religions rather than non-Christian religions.
Right.
But when you have a majority religion, take prohibition, for example, and somebody, if you have a viewer who knows otherwise, I'll stand corrected. But I believe that during Prohibition, there was an exception made for sacramental wine that was used in communion.
Oh.
Why? Because you have enough Christian denominations that believe wine is what should be used during, the Eucharist, or the Lord's Supper, whatever the denomination calls it. Whereas there's relatively few Native Americans, and fewer still, who adhere to the Apache view of the creation of the world in this particular site.
Right.
And that's when it's particularly important for the court to step in. And so in the 1940s and 50s, what was the most persecuted group in America? It was probably Jehovah's Witnesses, unless it would possibly be Japanese Americans, which are a whole
Right at
nother
the time.
story. But
But
Japanese.
not for religious reasons. The Japanese were not being
Right,
persecuted
that's
for
right.
religious
That's right.
purposes.
But Jehovah's Witnesses, first of all, they were conscientious objectors. You have to make a little qualification.
Right.
They would fight for God in the final battle if it were God against Satan, but they don't believe in fighting for one nation against another in other circumstances. So they're conscientious objectors. They don't believe in saluting the American flag because they believe that that's a form of idolatry. And 1941, if I remember, um, there's two decisions. Minersfield decision, about 1940-41. The Supreme Court says, if you're in a public school, you got to do what public school authorities tell you to do. And if they think saluting the flag is right, then you have to do it. And what happened, there were all throughout the United States, there were lynchings, there were castrations, there were imprisonment of a fair number of Jehovah's Witnesses. They were considered to be traitors. Well, 1943, after we go to war with the Nazis, and you begin seeing, Nazi children, raising their hands in salute,
Right.
some people say, well, maybe there's a little bit more to their beliefs than we've given them credit for. And in West Virginia State Board of Education, Justice Jackson notoriously says, if there's any fixed star in our constitutional constellation, it's that no official, high or low, shall be able to prescribe that which is orthodox in religion and force people to adhere thereto. And so, Jehovah's Witnesses subsequently, they also gained not a lot of friends by the fact that they were very aggressive in their evangelizing,
Right.
tended to knock on people's doors at times and continue when they didn't want to hear it, sometimes playing records that denigrated their own religions, and people didn't like them a lot. But the Jehovah's Witnesses lost, they brought like 70 to 80 cases to court, and they won 70, 80% or better of these cases during a 10 or 20 year period, which really solidified the notion that First Amendment freedoms are particularly important for minority religions. They can't
Right.
just, contact their representatives and get them to change the law. And that's why I think, I think, and again, you should understand, or I should explain rather, that Gorsuch is not necessarily saying how he would decide.
Right.
Okay, he's saying at the very least, we should give this, and he does say that in his judgment, the law would be on the side of Native Americans. Now, what I don't know about this case, and Gorsuch's decision doesn't go into it, I would be interested to know whether there was any possible compromise.
Mm.
Could there have been a way to move some of the sacred soil to another site? Would there have been another means of mining copper there that would not create a 1,500 wide or deep hole in a 2 mile, you know,
Well, and the other thing is this isn't a lake. This is copper mining, just like any
right,
mining, is not
right,
just a hole. It's how
right,
much structure beneath and above the ground to implement it.
right,
It's all of the machinery and the equipment and the comings and
sure,
the goings to make sure that it's moved out of and off of the site. This is not something that even is restricted to this fairly massive amount of land
right,
in length, in width and length
right,
and depth. So
right.
we're looking at basically, like you're saying, as if we were going to get rid of Notre Dame and not just get rid of it, but build this enormous site of, some kind of construction of copper under there. And that would go throughout
Well,
Paris.
what
You're
would we
looking,
say?
yeah,
What would we say if Native Americans discovered there was gold under Mount Rushmore and wanted to blow it up so they could mine gold?
right,
We would almost surely say, well, these are this has become a sacred pilgrimage site to many Americans.
right,
Clearly you can't do that.
yeah.
So I really, and this is the case, and Gorsuch is not particularly a hero of mine, but in this case, I think he wrote a very compelling decision.
Yeah, it's interesting, and it does appear that the minority religions are being cast aside when it comes to First Amendment freedoms and rights.
Well, again, put Smith and Ling in there with it,
Mm-hmm.
and you see a definite trend that would, if you had three decisions lined up like this against Quakers or against Catholics, almost surely you would have people from those denominations howling, as they
Right.
should.
So the other questions then that I have, and I want to make sure we have that this is a better understanding, is
Mhm.
this Religious Freedom Act. So we've got
Right,
the First Amendment, and I want to
right.
ask a couple questions about that, but then we have a separate law
Which
created
amendment?
by Congress. The first,
Yeah,
I
not for
hope.
me.
That whole
Okay.
First Amendment thing.
Yeah,
Um,
okay.
So we've got two separate laws, one that's embedded in the amendments and one that was created by Congress. So with the First Amendment, what does it specifically say with regard to freedom of religion? And I think it's a twofold, freedom and
It is.
establishment.
Right. Congress shall make no law respecting an establishment of religion or abridging the freedom thereof. So this falls primarily under that second clause, the free exercise clause.
Where it would bridge the exercise
Right. I
of
mean,
religion.
blowing up the place where you go to worship and you believe the world was created would tend to be a fairly significant impingement on your free exercise of religion.
It almost seems more like trying to blow up the Temple Mount, right?
Well, that would be similar.
For Christianity and it's three religions all together on the one, in the one building on the one
Right.
site, is if we're going to blow that up, which, three different religions hold sacred and have pilgrimages to and
Right.
believe, for some it's where Jesus and there's so
Sacrifice of Abraham. I'm
exactly
sorry, Abraham.
Isaac.
So Isaac, yeah.
Yeah, so it's like the beginnings and creation of three different religions in one site. Whereas, okay, so that seems more worldwide,
Right.
but why are we going to destroy somebody else's creation
Well, and
and their
again,
creation of the earth?
if you go back to early American history, pilgrims came over for freedom for themselves.
Mm-hmm.
And the Quaker showed up and they said, "There's the exit." And the Quaker came back and they hanged her. Um, and when Baptists showed up, they said, "You better get out of here." And they had to actually go found other colonies in order to exercise their religious freedom. And so, when the framers came along, that first clause, we're not going to have an established religion. We're not going to put one religion over another, and we're going to allow people to have free exercise of their religion. Now, again, Gorsuch is not saying there are no conditions under which you would ever regulate religion, but he's saying, look, Congress responded to this decision in Smith and said, we want you to go back to a compelling state interest that requires a substantial showing of governmental interest and a relation to that interest. And he says here that, mining copper on this site is not as important as freedom of religion. That's probably unpopular in a capitalist society,
Sure.
but there are things that are worth more than money.
Absolutely. So that brings us to the second one. This is much later in our country, the Religious Freedom Restoration Act. This is 1993.
Well,
So,
I'm sorry, I've gotten there. I just didn't label it.
oh, sure.
That's what the court adopts after the Smith decision to say we want you to go back to your former standard.
Right. But this is actually adopted by Congress.
That's right. Right. This is Congress saying, in our opinion, we need to give greater scrutiny to general laws that affect religion more particularly than the law on its face would suggest. On its face, this is a simple,
Right.
They're saying
It's
this should be different from, can you ever mine coal on a federal or copper on a federal site? There's an additional component here. This is a sacred spot that is valued. Are we just going to treat it like a regular commercial governmental transaction, or should it be given greater scrutiny?
Right.
And I think it's a clear case where greater scrutiny is required.
Yeah, I'm in agreement with you. I think the only thing that's going against that in any way in my mind is the fact that the land isn't Apache land. Yes, they use it. Yes, it's a site, but technically it has become federal land. So the federal government owns it.
Yeah, there's something else, though, that's peculiar here, and Gorsuch doesn't go into it as much as I would like him to. But Congress has, I think, 3 to 5 times, has tried to allow for the sale of this land. And each time they vetoed it. So what happened? The proponents stuck it on a defense bill.
Yes.
One of these so-called Christmas tree bills, stuck it in at the last minute, and they're proceeding on the basis of something that arguably did not get very much scrutiny at all.
Right. And
special interest stuck it in there, and it remained.
And that's what I think is a big warning to all of us, is these bills that are being created, whether it's the balanced budget ones or this big, beautiful bill or whatever is being created, the longer they are, the more these things get thrown in. And as you're saying, that it's a 2014 act, and it's the National Defense Authorization Act, 698 pages.
Yeah.
And all of a sudden, there's this little clause in there, the Land Exchange Act, which I'm not entirely sure has much to do with national defense, but it says,
copper.
Yeah, whatever.
Yeah,
but
it
says, okay, all of a sudden we give permission for mining here.
Okay, so I don't know. I think we're going to go next to discussion of this Court of International Trade.
We will
and
be.
You have something very similar.
Mm-hmm.
You have a president saying there's an international crisis because fentanyl is coming across the border. Right. So we're going to enact taxes of 50 to 145% across the board, right, under the authority of this, Trading with the Enemies Act or whatever. And, he's now threatening, since this decision, by the way, on Wednesday.
Since the Apache Stronghold decision.
No, I'm sorry. Since the new case that we just moved to.
Okay, well,
VOS versus US. I hope my transitions and lectures were better than this.
I remember them being that way, but it also, so you definitely finish your thought as a teaser for our next one. But this is definitely where we're headed. But finish that thought, especially with regard to concluding the religious part and these fillers.
Well, you say, there's a national defense interest, and that's, I mean, I'm sure if it went to court, they would say this is a compelling interest. Defense is important. Metals are important. One of those metals is copper. This is one of the mines of however many hundreds there are. And so we're going to cover it with that. So trade, you get the same kind of thing. Fentanyl is coming across the border, so we're going to enact tariffs on everything. Well, what do tariffs have to do with the flow of fentanyl?
Right, which is why this mining.
Nothing. There's almost no, to go back to that compelling state interest test, you have to show that there's a substantial reason and that the law is directly related to the interest that you're citing. And that's almost completely missing in both of these cases.
Yeah. Okay, so a lot to think about, and certainly another reason to put this as a higher part of the hottest legal news that you probably missed this week. And we want to make sure that you're thinking about it and how it applies to more of the overall things that are going on politically and how this affects each of us. Okay, we're not all Native American, we're not all Jehovah's Witnesses, but what does it mean for the other religions? What does it mean for our overall practice? And what does it mean for the idea and the part in our Constitution that prevents us from establishing a national religion? Is that what we're doing ultimately through the decisions in these cases? Are we putting away certain religions and establishing one over the other? So certainly something to think about. Dr. Vile, thank you so much for being our expert here on the Constitution and constitutional law. For most of you, you have to know that Dr. Vile his mind is a vault. And most of these cases and even the time periods, I'm looking at the article he wrote to make sure I know it. But he's coming up with most of these names and cases and time periods off the top of his head, which is absolutely incredible. But we're going to use some more of that expertise and information with our next one. The next one coming out will be about this international court and the international trades, as well as tariffs. And we're going to throw in pardon powers in there. We're going to go back to presidential powers and some congressional powers. So that'll be our next one. So join us then. And in the meantime, don't forget to hit like and subscribe so that you can follow us and that we can be referred to your friends. And we will catch you next time on the Legal Weekly Wine.